The limited liability company is a creature of statute. Its formation is outlined in law. If an owner fails to complete the steps articulated under the limited liability company law, the owner has failed to form an LLC. This could have severe consequences for the business owner, so be sure to comply with the statutory requirements. Generally speaking, forming an LLC is a four-step process. The first step is to choose the state of formation. This is called the home state. Where an entrepreneur forms is an important decision because of the internal affairs doctrine, which I will address in the next slide. Once a home state is chosen, an entrepreneur will complete the formation requirements in the home state and then apply for the requisite authority to do business where necessary. Once the statutory formation process is complete, the owners must draft an operating agreement. While I only listed 4 steps, forming a limited liability company in New York is not truly a 4-step process. We are going to break apart each step and look at how it is regulated under the law. The first step to forming a limited liability company is choosing the state of formation. This state of formation is called the home state. Choosing a home state is important because of the internal affairs doctrine, a legal rule mandating that disputes involving the internal affairs of an organization be governed by the laws of the home state. Entrepreneurs do not have to form in the state in which they operate, though many do. LLCs that form in a state in which they operate are called domestic limited liability companies. An entrepreneur, however, can choose to form in one state and operate in another. This entity is a foreign limited liability company. For example, if an entrepreneur chooses to form outside of New York but plans to operate here, it is a foreign limited liability company. Should business owners ever want or need to change their home state, this is possible. There can be tax consequences to this change, however. Owners looking to change the company's home state should retain an attorney to assist in the process. It's worth noting that as long as you are operating a business in New York, you must comply with the laws of New York. Foreign LLCs still pay New York taxes. Foreign LLCs must still register as a New York employer, and foreign LLCs must still comply with insurance, licensing, and other regulatory mandates in New York. It does not matter that the home state is not New York for tax, employment, and licensing rules. Let's move on to the individual steps to form a limited liability company. Depending on the choice of home state, there are 2 pathways to form a limited liability company. Remember, owners of a domestic LLC choose New York as the company's home state. Domestic LLCs must file articles of organization with the New York Department of State. While the company is formed upon filing the articles, New York law also requires the owners to file a certificate of publication within 120 days. The certificate of publication shows that the owners published a notice of the LLC's formation in 2 newspapers, 1 daily newspaper and 1 weekly newspaper, for 6 weeks in the county in which the company's office is located. The newspapers must be designated by the county clerk's office. Many county clerks list designated newspapers on their website. Once notice has been published for 6 consecutive weeks, the publishers of the newspaper will hand over an affidavit of publication for the owners to submit with a certificate. Foreign LLCs have an additional step. Owners must first complete the formation requirements of the home state's law. Then owners must file an application for authority to do business in New York with the Department of State and complete the publication requirement. For example, many entrepreneurs form their LLCs in Delaware. Delaware law mandates that businesses retain a registered agent before formation is complete. Should you choose Delaware as your home state, you must retain a registered agent in Delaware in addition to filing your formation papers with the Delaware Department of State. Then you will have to file an application for authority to do business in New York with the Department of State and file a certificate of publication within 120 days. Once an LLC is formed, owners must draft an operating agreement. In the next slides, we will go over the contents and the articles of organization and the operating agreement. Under the New York Limited Liability Company Law, the Articles of Organization must outline the following: the name of the LLC, the county in which the principal office sits, a designation of the Secretary of State as agent to receive service of process, the name and address of any person who may also act as agent to receive process, a dissolution date or triggering event if specified at the outset of the company's creation, any members who are to be liable for all or specified debts and obligations of the LLC, and a statement articulating that the company is to be managed by managers and not members, if the founders choose to do so. The Articles of Organization may also include any other item the founders wish to include in the formation documents regarding the internal affairs of the LLC, like voting majorities, for example. The Articles of Organization can be amended if there is ever a need to do so. Owners would file a certificate of amendment with the company's home state regulating authority to do so. The New York Department of State provides a template Articles of Organization on its website. It is linked in this resource for you to review.